give the state the power to control pollution and to take action against those who fail to comply with the law or the emission standards of the state. And over a period of years, what has happened for a variety of reasons is that these regulators become captive of the very organisations that they themselves are supposed to regulate and they themselves are to control. So what happens, Madam Speaker, is that a criminal rubbish dumper who needs to be brought to justice, who needs to go to jail, where prosecution guidelines need to be complied with, and his guilt determined by a jury and a sentence determined by a judge, does not happen because the EPA do not have, in my view, the capability or the ability to determine whether or not people should be prosecuted. There are other failures that have been brought to the Parliament's attention. There was a prosecution where hundreds of thousands of dollars were spent in respect of another corporation which was exposed at the Legislative Council estimates by the Honourable Luke Foley, which highlights the inability of this organisation to properly prosecute people for serious offences. Now, I just want to say this: the member for Campbelltown made a very conscious and considered contribution to this debate, and he made reference to the EPA's prosecution guidelines, and here they are. I have them here. I won't bother reading the clauses, but I assure the House that the EPA, in respect of the matter of Hannah, failed to comply with its own prosecution guidelines. Because on virtually, as one goes through every clause in their guidelines, there's nothing magical about the guidelines because they're similar to the Director of Public Prosecution's guidelines in New South Wales. They're similar to the guidelines that apply, for example, to the Director of Public Prosecutions in the United Kingdom. Now, on every single clause, almost every single clause that complies with the guidelines, the Hannah prosecution fitted within it. But most importantly, the guideline that is most important that was not applied and should have been applied relates to the question of general deterrence. One of the problems, one of the things that when the state prosecutes someone for a criminal offence, public interest and general deterrence plays a very, very, very big part. There has to be a message sent out to the community that this type of criminal conduct that is being prosecuted is not going to be criminal conduct that the state or the community will condone. And I could not think of a better act of general deterrence than to have indicted before the Supreme Court did Hannah for dumping asbestos said to be reasonably close to a school, unbonded asbestos, as sending a message to every other rubbish dumper, every other polluter that significantly harms the environment, that you're just not going to get a slap over the wrist, you're just not going to get a penalty notice, but you're going to be prosecuted on indictment and you're going to be sent to jail. I mean, the Minister for Environment, in respect of amending legislation last year, talked about how dreadful it was and how disgraceful it was. Well, it is dreadful and it is disgraceful, and the message needs to be sent out. Just as we sent out messages on we're not tolerating unprovoked violence in areas of the city, we send out messages that we do not tolerate the distribution and supply of drugs. We do not tolerate the conduct of paedophilia, and we do not tolerate the conduct of people who dump unbonded asbestos that is going to kill people. And the way in which we do that is we bring them to justice. And the way we bring them to justice is we charge them with the very offences that this Parliament has laid down. Now, the Environmental Protection Authority, in respect of the bill I propose, hasn't got its powers of investigation removed. I say that they are the appropriate authority to investigate allegations of breaches of environmental legislation. That they are effectively the law enforcement function. But what I do say, though, is that once they have completed that function and they reasonably suspect somebody may be guilty of a serious Tier 1 offence, they should consult the state's prosecutors. The prosecutors that this Parliament has set up to make decisions in respect of crime. And they should consult those prosecutors to determine whether or not those prosecutors should charge those people. Now, I say to the House this, and that is it should have confidence in the Director of Public Prosecutions. It should have confidence in the Crown prosecutors. And he could even, I would even concede that he could have confidence in the Environmental Protection Authority if it can find its activities either to prosecute minor offences or alternatively confine its activities to investigate the allegations of offences before consulting the state's prosecutors. The bill is not a bill to wedge the government. The bill is not a bill to turn environmental law and prosecution on its head. The bill is to remedy a particular failure to bring people to justice. I have not been able to find a single case, and I might be wrong, where anybody has been indicted for a Tier 1 offence before the Supreme Court or a jury. Now, that must say something, because the members of this House really believe that criminal rubbish dumpers have not committed Tier 1 offences. And the answer to that question, is obviously no. So the bill is a genuine attempt to try and repair and address a problem that was not foreseen. It may well be a resourcing problem. It may well be a lack of expertise problem, because in respect of anybody who engages in the practice in any particular field, it's a particular expertise as to whether or not people should be charged on indictment and how to go about that process, and the Director has it and the state has it. I commend the bill to the House.